The United States Supreme Court has just made a decision that could completely reshape the future of Social Security benefits in America, and millions of retirees, disabled Americans, and low-income beneficiaries still have no idea what's happening behind the scenes. This isn't some small legal update buried in government paperwork. This is a massive shift in power that experts are already calling one of the biggest changes to federal authority in decades. And if you receive Social Security retirement benefits, SSDI, SSI, survivor benefits, or any kind of federal assistance connected to the Social Security Administration, what happened in Washington could directly affect your monthly payments, your appeals process, and even your legal rights moving forward. For years, many Americans believed that once the Social Security Administration made a decision, that decision was nearly impossible to challenge. If the SSA denied your disability claim, accused you of being overpaid, reduced your benefits, or questioned your eligibility, most people felt powerless. The government had the final word, and the courts almost always sided with the agency. But now, after this historic Supreme Court ruling, that system has changed in a way nobody expected. Judges across the country may now have more authority to challenge how the Social Security Administration interprets federal law, and that could open doors for millions of Americans who previously had little chance of winning their cases. What makes this story even more shocking is that the impact will not be the same for everyone. Depending on the state you live in, your benefits, legal protections, Medicaid access, and supplemental payments could all be affected differently. Some retirees may suddenly discover they qualify for additional assistance they never knew existed. Others may realize they now have stronger legal grounds to fight denied disability claims or unfair overpayment notices. And many Americans who were told nothing can be done may finally have a second chance to challenge decisions that devastated their finances. That's why this discussion is so important right now, because the legal landscape surrounding Social Security is changing in real time, and the people who understand these changes first may have the greatest advantage. Over the next few minutes, we're going to break down exactly what the Supreme Court decided, why this ruling is sending shockwaves through the Social Security system, and most importantly, what actions beneficiaries should consider taking immediately to protect themselves, their income, and their future. Because once you understand what's really happening, you may never look at Social Security the same way again. What the Supreme Court actually overturned was something called Chevron deference, a legal doctrine that had quietly controlled the balance of power between federal agencies and the American people for more than 40 years. Most Social Security beneficiaries had never even heard the term before this ruling, yet its impact shaped nearly every major decision the Social Security Administration made regarding benefits, eligibility, disability approvals, overpayments, and appeals. Under Chevron deference, when Congress passed laws that contained vague or unclear language, federal agencies like the SSA were allowed to interpret those laws themselves. And perhaps even more importantly, courts were expected to defer to the agency's interpretation unless it was considered completely unreasonable. In practice, this gave enormous power to the Social Security Administration and made it extremely difficult for ordinary Americans to successfully challenge agency decisions in court. Think about what that meant in real life. Imagine a retired worker receiving Social Security benefits who suddenly receives a letter claiming they were overpaid thousands of dollars years earlier. Or a disabled American whose SSDI claim gets denied because the SSA decides their condition does not meet the agency's interpretation of disability standards. In many of these cases, even when beneficiaries believed the agency was wrong, courts often sided with the SSA because of Chevron deference. Judges were not independently interpreting the law. They were giving the benefit of the doubt to the agency itself. That system created frustration and hopelessness for millions of Americans who felt trapped inside a bureaucracy that controlled both the rules and the interpretation of those rules. But the Supreme Court's unanimous decision changed that structure dramatically. Now, judges are no longer required to automatically side with federal agencies when laws are unclear. Courts themselves can independently interpret the law. That may sound technical, but the implications are enormous. Suddenly, beneficiaries who challenge SSA decisions may find themselves standing on far more equal legal ground than at any point in the last 4 decades. This is why disability attorneys, retirement advocates, and legal experts across the country are paying extremely close attention to what happens next. Because this ruling could trigger a wave of new lawsuits, appeals, and legal challenges involving Social Security policies that previously seemed untouchable. One of the biggest areas affected involves Social Security overpayments. Over the past few years, hundreds of thousands of Americans received shocking notices from the SSA demanding repayment of benefits the agency claimed were sent incorrectly. In some cases, beneficiaries were told they owed tens of thousands of dollars, even though the overpayments were often caused by administrative errors or delays within the SSA itself. Many retirees and disabled recipients had already spent the money on rent, food, medication, and basic living expenses because they believed the payments they received were accurate. Some people suddenly faced the possibility of having their monthly benefits reduced or withheld entirely to repay debts they never even knew existed. Before this Supreme Court decision, fighting those overpayment determinations was incredibly difficult because courts generally deferred to the SSA's interpretation of its own authority. But now judges can independently examine whether the agency's collection practices and calculations are actually supported by federal law. That shift could become one of the most important legal protections Social Security beneficiaries have seen in years. Attorneys are already exploring whether some overpayment recovery methods go beyond what Congress intended when creating the Social Security Act. And if courts begin ruling against the SSA in those cases, the impact could spread nationwide. Disability claimants may also see major consequences from this ruling. The SSA has long used its own internal standards and interpretations to determine whether someone qualifies as disabled under federal law. Many applicants who suffered from severe medical conditions were denied benefits because the agency concluded they could still perform substantial gainful activity under SSA guidelines. But critics have argued for years that some of these interpretations became overly restrictive and disconnected from the realities disabled Americans actually face. Under the old system, courts frequently upheld those agency interpretations. Under the new framework, judges may now have greater freedom to question whether the SSA's disability standards truly reflect what Congress intended. That possibility is creating renewed hope for many Americans whose disability applications were denied in recent years. Legal advocates believe some denied claimants may now have stronger grounds for appeal than they did before. And because many Social Security disability attorneys work on contingency, meaning they only get paid if benefits are awarded, more beneficiaries may begin seeking legal representation to revisit cases they once thought were hopeless. Across the country, disability law firms are closely monitoring federal court decisions that could establish new precedents in the months ahead. Another critical issue involves SSI asset limits. The Supplemental Security Income Program has strict financial resource caps that determine eligibility. For decades, those limits have remained painfully outdated, despite inflation dramatically increasing the cost of living. Currently, an individual can lose SSI eligibility if their countable resources exceed just a few $1,000s. Critics have long argued that these limits punish vulnerable Americans for attempting even minimal financial stability. The SSA also maintains extensive rules defining what counts as a resource and what does not. Those interpretations now face a much more uncertain legal future because courts can independently review whether the agency's definitions are truly supported by the law itself. At the same time, the ruling highlights something many beneficiaries still do not realize. Social Security does not operate identically in every state. SSI recipients especially can experience major differences depending on where they live. Some states provide substantial supplemental payments on top of the federal SSI benefit, while others offer little or nothing additional. Medicaid eligibility rules also vary significantly across states, creating huge differences in healthcare access for low-income seniors and disabled Americans. That means your location can directly affect not only how much assistance you receive, but also what legal protections and support systems are available if problems arise with your benefits. Because of these differences, advocacy groups are encouraging beneficiaries to become more proactive than ever before. Experts say every Social Security recipient should regularly review their My Social Security account online, check earnings histories for mistakes, monitor payment changes carefully, and document every communication received from the SSA. Even small errors can eventually affect benefit calculations, retirement payments, or future eligibility determinations. And under this new legal environment, properly documented disputes may carry far more weight than they did in previous years. Legal experts are also warning beneficiaries not to ignore notices from the SSA. Many people become overwhelmed or frightened when they receive letters involving overpayments, benefit reductions, or eligibility reviews. But now more than ever, responding quickly may be critical. Beneficiaries have appeal rights, waiver rights, and opportunities to challenge agency decisions, and those opportunities could become increasingly important as courts begin interpreting Social Security laws more independently. Missing deadlines or failing to respond could still create serious financial consequences, which is why many attorneys are urging people to seek legal advice immediately if they receive concerning notices from the SSA. What makes this moment so historic is not simply the legal technicalities of the ruling itself, but the broader shift in power it represents. For decades, federal agencies operated with enormous interpretive authority that often left ordinary Americans feeling powerless. Now that balance is beginning to change. Courts may become far more active in determining how Social Security laws are applied, and beneficiaries who understand these changes early may be in a much stronger position to protect themselves financially. The system is entering a period of uncertainty, but uncertainty also creates opportunity, especially for individuals willing to learn their rights, stay informed, and take action when necessary. And perhaps the most important thing to understand is this: the full impact of this Supreme Court decision has not happened yet. The real consequences will unfold over the next several years as new lawsuits move through federal courts and judges begin applying this new standard to Social Security disputes nationwide. Some policies may survive unchanged. Others could face major revisions. Certain legal challenges that once seemed impossible may suddenly gain traction. That is why millions of beneficiaries, retirees, disabled Americans, and surviving family members need to pay close attention right now. Because the rules surrounding Social Security are no longer as settled as they once appeared, and what happens next could affect the financial future of millions of Americans for years to come. Before you go, remember this: staying informed is no longer optional when it comes to your Social Security benefits, retirement income, and financial future. The rules are changing, court decisions are reshaping the system, and the people who understand these changes first are often the ones best prepared to protect themselves and their families. That's exactly why this community exists. Here at WealthWise Seniors, our mission is simple: to help retirees, seniors, disabled Americans, and everyday beneficiaries stay one step ahead with clear, easy-to-understand updates that actually matter to your life. If this video helped you in any way, make sure you subscribe to WealthWise Seniors right now and turn on the notification bell so you never miss an important update. New Social Security rules, SSI changes, SSDI news, Medicare updates, retirement strategies, stimulus developments, and legal decisions can happen fast. And we're here to break everything down in plain English without the confusion. Also, don't keep this information to yourself. Share this video with a friend, a parent, a spouse, or anyone who depends on Social Security benefits. One share could help someone avoid costly mistakes or discover benefits they didn't even know they qualified for. Thank you for being part of WealthWise Seniors, where smart retirees stay informed, protected, and prepared for the future.